Dear viewers, in the last session we discussed audit and books of accounts, and in this session we are going to discuss inspection, inquiry and investigation. The objectives of the lesson are to explain the procedure for conducting the inquiry and inspection of the documents of the company by the government official. The lesson also explains the powers of the inspectors of the government. Overall maximum managerial remuneration. Effect of inadequacy of profits. According to section 2 subsection 78 of the Act, remuneration means any money or its equivalent given or paid to any person for services rendered by him and includes perquisites as defined in the Income Tax Act 1961. The total amount of remuneration payable by a public company to its directors, including managing director, whole-time director and its manager for any financial year is not to exceed 11% of the net profits of the company computed in the manner provided by section 198 of the Act. The remuneration of the director is not to be deducted from gross profits. The company in general meeting may, with the approval of the central government, pay in excess of 11% subject to the provisions of the Schedule 5. With the approval of the company in general meeting, remuneration payable to any one MD, whole-time director or manager may exceed 5%, and if there is more than one in such category, it is not to exceed 10% for all of them put together. Remuneration payable to directors simpliciter is not to exceed 1% of the net profits of the company if there are any managerial personnel, otherwise 3%. This percentage is exclusive of any fee payable for attending board or committee meetings under subsection 5. If in any financial year a company has no remuneration or inadequate profits, the company cannot pay anything to any category of directors except as provided in Schedule 5. If the company is not able to comply with the provisions of the schedule, it should take previous approval of the central government. The remuneration payable to all the categories is to be determined in accordance with the provisions of the section, whether under the articles or by a resolution, and if articles so require, by a special resolution passed by the company in general meeting. The remuneration payable to director as so determined to be inclusive of remuneration payable to him for services rendered by him in any other capacity. But it does not include the services rendered by him in any professional capacity. A director or manager may be paid remuneration either by way of a monthly payment or at a specified percentage of the net profits of the company, or partly by one way and partly by the other. Where the company is suffering from no profit or inadequate profit, it cannot increase remuneration of any person in any way whatsoever except either in accordance with the schedule or otherwise with the approval of the central government. Chief Financial Officer. It means a person appointed as the Chief Financial Officer of the company. Secretary. Section 2, subsection 24 of the Act provides that the expression secretary means a company secretary within the meaning of section 2, subsection 1, clause C of the Company Secretaries Act 1980. Power to call for information, inspect books and conduct inquiries. According to section 206 of the Act, where on a scrutiny of any document filed by a company or any information received by him, the registrar feels that any further information or explanation or documents are necessary, he may require the company by a written notice to furnish in writing such information or explanation or to produce such documents. He may specify in his notice a reasonable time for the purpose. Then it becomes the duty of the company and its officers to comply with the notice. The ROC may extend time for compliance. If the ROC finds on the basis of the information or on representation made to him that the business of the company is being carried on for a fraudulent or unlawful purpose or not in compliance with the Act, or the grievances of investors are not being addressed, the ROC may inform the company of the facts and seek its reply and may order an inquiry after giving the company a reasonable opportunity of being heard. The central government may, if it is so satisfied that the circumstances warrant it, direct the ROC or inspector appointed by it to carry out the requisite inquiry. When it appears that the business of the company was carried on for a fraudulent or unlawful purpose, every officer in default would be punishable for fraud in the manner as provided in section 447 of the Act. The government can also order inspection of books and papers by an inspector appointed by it or to get it done by a statutory authority. Failure to comply with orders under this section makes the company and defaulting officers punishable with fine extending to 1 lakh rupees and in the continuing default an additional fine extending to 500 rupees for every day of default. Conduct of inspection and inquiry. According to section 207 of the Act, the inspectors have the powers of civil court under the Civil Procedure Code in respect of the following matters: the discovery and production of books of account and other documents at such place and time as may be specified by such a registrar or inspector making the inspection or inquiry; summoning and enforcing the attendance of persons and examining them on oath; inspection of any books, registers and other documents of the company at any place. Disobedience on the part of the directors or officers makes them punishable with imprisonment extending to 1 year and fine of not less than 25,000 rupees and extending up to 1 lakh rupees. Report on inspection. According to section 208 of the Act, after completing the inspection and inquiry, the ROC or inspector has to submit a report in writing to the central government along with documents if any. The report may include a recommendation that a further investigation into the affairs of the company is necessary. Investigation distinguished from inspection. 1. Inspection of books of account and other papers is not an investigation, though it may eventually lead to investigation. Investigation includes all business affairs of the company. 2. Inspection can be done by ROC or by such officer of the government. The inspectors may be appointed for conducting investigation from amongst the officers of the government. 3. The inspecting authority need not give any reasons for inspecting the books of accounts of the company. In case of investigation by the government, it has to give reasons for investigation. 4. In case of inspection, the inspecting officer can inspect only that company for which he is so authorized by the central government. In case of investigation, the officer has the power to investigate into the affairs of the holding or subsidiary of the company which is being investigated. 5. The expenses of inspection are to be borne by the central government and are not recoverable. In case of investigation, the expenses are defrayed in the first instance by the central government but are to be reimbursed by the applicants subsequently. Power of investigation. The Act provides that in appropriate circumstances, the central government may investigate into the affairs of a company under sections 210 and 213 or into ownership of shares of company under section 247 of the Act. It must be pointed out that the investigation into the affairs of a company may either be mandatory as provided in subclause A of section 213 or it may be discretionary at the discretion of the central government under section 235 and subclause B of section 213. The provisions relating to investigation into ownership of a company as contained in section 247 and 248 are however mandatory in nature. Search and seizure. According to section 209 of the Act, whereupon information in his possession or otherwise the registrar or inspector has a reasonable ground to believe that books and papers of the company or those relating to key managerial personnel or any director or auditor or company secretary are likely to be destroyed, he may obtain an order from the special court for seizure of such books and papers. The provisions of the Criminal Procedure Code 1973 relating to search and seizure are to apply to every search and seizure under this section. Investigation into affairs of company on tribunal's order. According to section 210 of the Act, where the central government is of opinion that it is necessary to investigate the affairs of a company because of the ROC or inspector under section 208 or on the basis of the company's special resolution for investigation or in public interest, an order of investigation may be passed. The central government has also to order investigation when an order is passed by a court or the tribunal in any proceedings before it. One or more inspectors may be appointed who are to submit their report to the central government. Sections 210 to 229 provide for investigation of the affairs of a company. Section 213 of the Act makes it obligatory on the part of the central government to appoint inspectors to investigate into the affairs of a company in the following two circumstances. On members' application, when the company has evidence and they demanded such an investigation by a special resolution. When members apply, they must support their application by evidence and they may be asked to give security for cause of investigation. The evidence must show that the applicants have good reason for requiring the investigation. The tribunal will give an opportunity to the parties of being heard. It may then declare that the affairs of the company ought to be investigated. On such a declaration being made, the central government has to appoint one or more competent inspectors to investigate the affairs of the company and to submit a report thereon in such a manner as the government may direct on discretion of tribunal, where the tribunal by order declare that the affairs of the company ought to be investigated by an inspector or inspectors appointed by the central government. It also lays down that in 3 cases in which the tribunal can appoint inspectors on its own motion, the section empowers the tribunal to ask the government to act if there are circumstances suggesting the following: fraud, oppression or illegality, that the business of the company is being conducted with intent to defraud creditors, members or any other person, or for a fraudulent or unlawful purpose, or in a manner oppressive to certain members, or that the company was formed for any fraudulent or unlawful purpose. Fraud, misfeasance or misconduct, that the persons concerned with the formation of the company or management of its affairs has been in connection therewith guilty of fraud, misfeasance or other misconduct towards the company or towards any of its members. Inadequate information, that the members of the company have not been given all the information with respect to its affairs which they might reasonably expect, including information as to commission payable to the managing director or manager. Besides the power of the tribunal to order investigation under section 213 clause A, the Act also makes it mandatory for the central government to hold an investigation into the affairs of the company upon an application from not less than 100 members or members holding at least 1/10 of the total voting powers in case of a company having share capital, and not less than 1/5 of the members in case of a company without a share capital. On receipt of such application, the tribunal, after giving the parties an opportunity of being heard, would make an order declaring that the affairs of the company ought to be investigated by one or more inspectors. The central government may require the applicants to deposit security for costs of investigation not exceeding 1,000 rupees before appointing inspectors for investigation into the affairs of the company. Where the tribunal rejects the application, a member may apply to the appellate tribunal. The decision of the central government to appoint inspectors under section 210 subsection 1 or section 213 clause B being an administrative decision, the tribunal will not generally interfere unless mala fide or bad faith is proved. Security for payment of costs and expenses of investigation. According to section 214 of the Act, the central government may require, before appointing inspectors, the applicant to give such security not exceeding 25,000 rupees as may be prescribed for payment of expenses of investigation. The security amount is to be refunded to the applicant if the investigation results in prosecution. According to section 215 of the Act, no firm, body corporate or other association is to be appointed as an inspector. It therefore follows that only individuals can be appointed as inspectors and not any non-living entity. Procedure and powers of inspectors. According to section 217 of the Act, the inspector appointed to investigate the affairs of a company is vested with adequate powers under the Act. The powers of the inspectors are as follows. Power to enforce production of documents. Section 217 of the Act provides that in order to facilitate the task of the inspector, it is the duty of the inspector and all officers, employees and agents in charge of the management of the company to procure and produce before the inspector any books, papers of the company which are in their custody. They should extend to the inspector every kind of assistance in connection with the investigation which they are reasonably able to give. The inspector may also, with the prior approval of the government, require any body corporate other than body corporate whose affairs are being investigated furnish such information or produce such books and papers before him as he considers necessary. If a person required to appear or produce books makes a default, he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 25,000 rupees, or with both, and also with a further fine which may extend to 2,000 rupees for every day during which the default continues. Power to keep books in custody. The inspector investigating into the affairs of a company may keep in his custody any books and papers produced before him for 6 months and thereafter shall return the same to the company. Power to examine on oath. The inspector may examine any past or present officers or any other employees or agents of the company in relation to matters connected with the affairs of the company under investigation. Power to investigate affairs of related companies. Section 219 of the Act provides that if the inspector considers it necessary to investigate even the affairs of another company under the same management or in the same group, he may do so. Power to seizure of the documents. Where an inspector has reasonable grounds to believe that relevant books and papers may be destroyed, he may make an application to the magistrate of first class and obtain an order for seizure of such books and papers. Report by inspector. On conclusion of investigation, the inspector shall prepare a report and submit it to the central government. He may also be directed by the government to make interim reports to the government. Consequences of inspector's report. On receipt of the report of the inspector, the government may initiate any of the following actions. 1. Where from the report made by the inspector it appears that any person has been guilty of an offence in relation to the company, the government may take steps to prosecute such person. 2. If the central government forms an opinion that it is expedient to wind up the company for reasons as specified in the report, such as the company trying to defraud its creditors, members, etc., or carrying on business for an unlawful or fraudulent purpose, it may cause a petition filed for a winding up order under section 241 of the Act. Serious Fraud Investigation Office. According to section 211 of the Act, the central government has to establish an office called Serious Fraud Investigation Office to investigate frauds relating to companies. According to section 212 of the Act, where the central government is of opinion that it is necessary for SFIO to investigate into the affairs of a company? A. On receipt of a report of the ROC or inspector under section 208. B. On intimation of special resolution passed by a company to the effect that its affairs are required to be investigated. C. In public interest. D. On request from any department of the central or state government, the central government may assign the investigation to SFIO. On completion of investigation, the report has to be submitted to the central government. An inspector may, with prior approval of the central government, investigate into the affairs of the related companies if he considers it necessary for the task of his main investigation. Investigation of ownership of a company. According to section 216 of the Act, public interest may sometimes require the central government to know the persons who are financially interested in a company and who control its policy or materially influence it. Then the central government may appoint inspectors to investigate and report on the membership of company and other matters relating to it. The tribunal is also having the same powers. On the orders of the tribunal, the government is bound to appoint the inspectors to investigate the ownership of the company. By hearing this lesson, the viewer will come to know the powers of the government inspector while conducting investigation and enquiry against the company against whom the company is received by the government. I hope you enjoyed the lesson and we will meet in the next session. Thank you one and all.